Attorneys for Alex Murdaugh are now asking for a new murder trial based on discoverable evidence. Today, I talk one-on-one with local attorney Susan E. Williams for her analysis on this case for this edition of Quintin's Close-Ups. And if you haven't already, subscribe to my YouTube channel and like Quintin's Close-Ups on Facebook.
Attorney Susan E. Williams, welcome back to Quintin's Close-Ups.
Thank you for having me.
Oh, you're very welcome. Needless to say, I've had you on Quintin's Close-Ups in the past couple of months to discuss Alex Murdaugh and his murder trial. And today we have some new developments in that particular case. The Law and Crime Network reports that Alex Murdaugh's attorneys are filing for a new murder trial based on, quote, discovered evidence, unquote. Attorneys for Murdaugh are actually asking SLED to step away from this particular situation, demanding a federal investigation into the trial, accusing the Colleton County Clerk of Court of jury tampering and violating Murdaugh's civil rights. And they were actually seeking a new trial. I know that for background, Murdaugh actually is a disbarred attorney who was sentenced to life without parole in March for the murders of Maggie and Paul Murdaugh after jurors found him guilty in the 2021 slayings. He also faces a slew of charges over alleged financial crimes during this year as a lawyer. And just this morning, Susan, news broke that attorney and state representative Justin Bamberg is representing the Colleton County Clerk of Court, Becky Hill, along with attorney Will Lewis of the Richardson Thomas firm. So let me ask you this, Susan. As an attorney, does this appear odd to you that they're actually calling this, quote, after discovered evidence, simply because the term is typically referred to as evidence about the crime would actually point to innocence?
Well, I think the after discovered evidence that the Murdaugh team lawyers are trying to say that they have discovered, if those allegations are true, is that after the trial was over with, they learned that these things that they're alleging happened. So, I think that's the after discovered evidence. I don't think it really has to do with the actual crime itself. It has to do with the criminal procedure process that went on during the jury trial.
Oh, and isn't it true that there's a rule that a motion for a new trial based on after discovered evidence must not be made during the pendency of the appeal unless an exception is made and must be brought within a year of that discovery?
That's right. So newly discovered evidence can be brought during an appeal, but just to make things very simple to understand the process, the appeal basically goes on pause. So the Court of Appeals is a court that's a higher court than General Sessions Court, where Judge Newman was presiding. So right now, there is an appeal that's active. And so one of the things that the Murdaugh team has asked in their recent filing is that Court of Appeals document, if you will be put on hold. And then in the meantime, this motion will be heard for a new trial.
And isn't the allegations of improper juror influence would be something totally different from this?
The allegations would be something totally different than what is on appeal. That's correct. This is a new topic of allegedly newly discovered evidence.
Yes,
and so that's one of the reasons, yes, sir, why they are asking for the appeal to be, the legal term is stayed, but to understand that it just means it's put on pause until this part can be handled.
And do you think, Susan, that the defense will make a request for a Rimmer hearing where it would have the burden of showing actual bias by a juror?
Well, once this motion is filed, I think what you're asking me is who the burden is on the state or the Attorney General's office. If you'll remember, the lead prosecutor was Quintin from the Attorney General's office. And so the burden of proof will be on the state to counteract what the defense has alleged in its motion.
And can they actually, as far as the Murdaugh team, can they actually get a hearing if the issue had been actually addressed at trial when the defense was consenting to that particular resolution?
As far as, as far as the newly discovered evidence, or?
Yes, ma'am.
Well, they're claiming that what they know now is different than what they knew during the trial. So, there are a few things that have to happen before we can have a hearing, or they can have a hearing on this. I don't represent anyone involved in this.
Right.
But so So the Court of Appeals, they must first decide that they're going to stay their action. They're going to put their action on pause. Then the attorney, and also the Attorney General's office, has 10 days to respond to this motion that the defense has brought forward. They can, of course, ask for an extension. So we're kind of waiting on that, and I'm interested to see what the Attorney General's office response is as well. So it isn't like as simple as just let's file a motion and then we'll have a hearing and then everything happens kind of like what you see on TV. It's a lot different than that. A lot goes into these motions and looking at all of the stuff. So, there are a lot of hoops to jump through before we actually get to a hearing, if we even get there, if they get there.
Susan, do we know if the jurors whom they apparently spoke to, meaning the Murdoch team allegedly, are even jurors who actually deliberated during that particular trial?
If they are not the actual jurors that deliberated during the trial, then I think that would definitely be a problem for the Murdaugh lawyers, because as officers of the court, what they're putting into these motions, and they're supposed to be, giving what they know to be true upon information and belief. So I would presume that if they say it's a juror that they have spoken to that actually who this person says that they are, then I would presume that that's the actual person who wrote the affidavit.
And I know that one juror mentioned in said motion was released for false misconduct reportedly. So was the other an alternate and not actually involved in deliberations?
I'm not really sure exactly which. I know that we went through quite a few of the alternative jurors, like when one juror was dismissed, another one came up. I don't know exactly which jurors were dismissed and which ones ended up. I just know that I think we had maybe like 5 alternates, and I think we used up 4 of them. So I'm not entirely sure which ones are which, and there was an order by the judge that jurors not be mentioned by juror number. That was an order during the trial. And so I really don't know exactly which ones, what number goes with which ones that were there, because I think a lot of that was confidential so that everyone could comply with Judge Newman's order.
Yeah. And many people who are watching this right now, Susan, may be asking, why didn't the jurors share this misconduct with the judge?
Right. And I've seen that same question addressed a lot, and it was addressed in the press conference. And what the Murdoch team said was that what I understood is that they tried to reach out to the jurors and they were met with a cone of silence. So the jurors were resisting talking to them. And then they said once the book came out, that had something to do, at least had some part of why the jurors wanted to talk. And I noticed the way that it was phrased, and this just be me, it wasn't clear to me like if the jurors actually reached out to the defense attorneys after the book was released, or whether the defense attorneys reached back out to the jurors. What I understood from the press conference was the jurors were, some of them were willing to come forward. That, I believe that was the phrase that was used. So maybe I'm overanalyzing things here, but I thought that was quite interesting, the timing of it. I mean, it could be a number of things, but that was what I have heard mentioned.
And obviously, Buster Murdoch did an exclusive interview with Fox Nation about obviously what transpired during the trial and his family and whatnot. Do you think that actually had a play in this press conference that the defense team had recently?
You mean the timing of the Fox Nation and, yes, and the conference?
Exactly. Well, right.
Some people have said that, but lawyers can file documents without having a press conference. Certainly, that certainly is their option, and the Murdoch team probably has planned things strategically. I'm not privy to what their plans are and the timing of it, but I did watch that, and I enjoyed hearing. I thought that was a great, just being able to hear both sides of the state side, the defense side, the three documentary. And we finally got to hear from Buster Murdaugh for the first time publicly since the trial.
And speaking of all of that, let me go back to obviously attorney and state representative Justin Bamberg. Could this be a conflict of interest for Bamberg since he's handling a case that is part of the receivership against Alex Murdaugh?
That if it were a potential conflict of interest, that conflict of interest could be waived in writing, I would think, by the clerk of court. There's also another attorney on there, working with Representative Bamberg, and what Representative Bamberg, who he represents, is someone that had to do, like, one of the people that he represents. I know Hakeem Quintin's family, and so that has to do with, that is a completely separate issue, if you will, than the issue that is going on allegedly with Becky Hill. So I don't see it as a conflict of interest, and I would be very surprised if Justin Bamberg, just knowing what I know about his stellar reputation, I would never think that he would take on something that would be a conflict of interest. And I have a lot of respect for Justin Bamberg and his ability as an attorney. I don't know him personally, just what I've read about him. I've met him once, and but what I know of him ethically, I don't think that he would ever take on something like that and risk his whole entire legal career and his career as a legislator.
And thank you so much for navigating us through all of the new developments in this particular case, lawyer. And yes, indeed. Yes, ma'am. Well, attorney Susan E. Williams, thank you for your time. And again, welcome back to Quintin's Close-Ups.
Thank you. Thank you for having me.
Oh, you're welcome.